Hi, I'm attorney Ben Schwartz, and today we're doing video 3 out of 3 on the topic of immunities in Delaware personal injury cases. And today we're going to talk about the Delaware Premises Guest Statute. So just to bring you up to speed, maybe you didn't watch the first 2 videos, but what I essentially do is handle personal injury cases. Personal injury case most of the times is going to be a case where my client was injured in an accident. We're filing a lawsuit or making an insurance claim against someone who was at fault for causing an accident that resulted in my client's injuries. And so that is called a negligence lawsuit or a negligence claim. And within the context of a negligence claim, there are immunities. So essentially, immunity means that because of some special status, the careless or negligent defendant is going to say, you know, I might have been negligent, I might have been careless, I might have caused injuries, but you can't sue me because I'm immune from the lawsuit. You know, I'm essentially given special protection by the law because of my status. Now, one of these types of immunities that comes up quite frequently in Delaware personal injury negligence cases is the immunity that is conferred by the Delaware Guest Premises Statute. This statute says that if you are a guest without payment on private residential property or on farm property and you're injured on the property due to some defect or some condition that was allowed to exist, you can't sue the owner of the property. And there are some exceptions to this. If you've had, if you yourself are watching this because you were injured on someone's property, you should contact an attorney who handles these types of cases and get a consultation so you know where you stand. But generally speaking, this is what the law is, at least in Delaware, with respect to accidents occurring on private residential or farm property. There's exceptions to this rule. You know, there's exceptions for if it's an intentional act or if it's a reckless, willful, and wanton type of condition. But generally speaking, the thing to keep in mind is that in your ordinary negligence situation, the premises owner, the homeowner, the farmer at the farm can carelessly injure people and get away with it because they're given immunity under the Premises Guest Statute. So I guess my question is, as a viewer of my video, what do you think? Do you think that this is a good thing? Do you think this is a bad thing? You know, as a property owner, if you're a property owner, should you be able to carelessly or negligently care for your property, let dangerous conditions come into existence, let those conditions injure your friends and family members, and have no responsibility for it, legally speaking? Do you think that it's right? I mean, in most cases, if you're an owner of property or you're a renter of property, you know you've got insurance coverage to cover personal injury cases, to cover bad things that could happen on the property. I mean, essentially, aren't we giving the insurance companies a free pass to avoid paying on claims after they've collected premiums? You know, the insurance companies provide the insurance in return for getting paid to provide insurance. If they're getting paid to provide insurance, why shouldn't they cover a personal injury claim in one of these situations? Or is this a good thing? And maybe you're a property owner and you think that, you know, there's too many people bringing lawsuits, and maybe you've had some experience with a negligence claim or a lawsuit, and maybe you have a point of view that's contrary. So I'd be interested to know what you think as a viewer of my video. Is this a good thing, a bad thing? What's your experience been, and why do you hold your particular view? Comment on our video on our Facebook page. We're at facebook.com/Schwartz&Schwartz, or you could send me an email. My email address is ben.schwartz@schwartzandschwartz.com. Thanks for watching.